Welcome to Protect What Matters, Estate and Elder Law with Tim Murray.
Welcome to Protect What Matters, Estate and Elder Law with Tim Murray. A Winnemac lawyer in Indiana, Tim has more than 35 years of experience helping Indiana families with estate planning, probate, and elder law matters. I'm Evan Mack, and today we're talking about how probate works in Indiana and what families can expect along the way. Tim, sir, welcome.
Thank you, Evan. Thank you very much. Great to be here.
Awesome stuff. We're going to get into it. Understanding probate, what happens after a loved one passes away. But before we get into today's topic, can you share a little bit about your background and what led you to focus on helping these families here in Indiana, with
Sure.
estate planning and probate?
Sure. Yeah. I come from the area where I'm sitting right now, Winnemac, Indiana, and the surrounding county and areas. And I grew up on a farm. And when I came back to Winnemac to practice law, it became quite apparent that there weren't a lot of lawyers in our area doing estate planning, or at least in any depth. And I guess the shocker to me is when I talked to some friends of mine, and they said they were driving to Fort Wayne, which is about an hour and a half or 2 hours from here. And I said, "What for?" They said, "Well, we have to go see an estate planning lawyer." I go, why are you going there?" And they're like, "Well, nobody around here does it." So I quickly self-educated and went to more continuing legal educated seminars, went back to school and boned up on estate planning. Well, that was over 20 or 25 years ago in my 35-year stretch as a lawyer. So that was my the biggest thing that happened that got me into this. I love to do it. It's great to work with families and take care of things. I'm kind of a social creature and like to talk a lot. And it's great to sit down with families and do those things and help them put some purpose and do some things with their estates and plan for themselves and their families and the next generations, or even the generations above them when things are going to happen.
So Tim, can you explain in plain terms what probate is and what its purpose is in Indiana?
Sure, Evan. The probate process in Indiana, the law says when you die, if you're worth over $100,000 in your gross assets, and they'll subtract out mortgages and liens and encumbrances as the legal terminology, but it's debt. They'll subtract off debt, and if you're worth over $100,000, you have to go through probate. That's the law. Doesn't matter if you have a will or not. You have to go through probate. So we go through the probate process begins, and it usually is going to take anywhere from 6 months to 8 if we're lucky. That's what we try to shoot for. And then, but the process involves administering your assets, inventorying assets, looking at all your debts. Who do you owe money to? Sometimes if you open up a newspaper and in the back of the newspaper and the ads, you see someone's estate being advertised. And people don't know what that always means, but that's called notice by publication. You have to run those ads in the paper so that anybody you don't know about that the deceased person might owe money to, they get notified. So there's a whole process under Indiana law that instructs how to do these things. If you have a will to probate, then that's also submitted to probate, and the instructions and everything in your will be adhered to. Again, it opens itself up to creditor claims, maybe Medicaid claims if you had a stay in a nursing home and were on Medicaid. There's a lot of processes and things that need to be handled, and I think it can be overwhelming for someone down the line if they don't have the assistance of an experienced attorney in probate matters. So,
well, what happens if somebody, right after they pass away? What are the first, practical steps a family should take before the court process even begins?
The best thing to do, well, the first thing I always tell families, sometimes I get a call the day someone dies, or the day shortly thereafter, and everyone seems to be in a hurry. They're grieving, they're mourning, they've just lost a loved one. And I always tell people, look, you take care of yourself, you take care of your family, you mourn, you grieve, you do the funeral thing and do those, because there's nothing that we can't take care of. And if something does happen, there's nothing we can't fix. So I always want to emphasize, take care of yourselves and your family and go through the process. But nonetheless, people still want to come in and see me as quickly as possible. I guess what I would advise is try to get organized. Even if your family member who died has everything in shoe boxes and dresser drawers, and I call it the sock drawer. Everything's
Yeah.
stuffed in a sock drawer, or just gather it all together. And paperwork. If you can get into a lockbox, get into a lockbox. Do those, gather things up, because we need to know what the assets of the deceased person are, what the debts are, and being organized and having those all in one piles. I'm an old farm boy. I talk like that a lot. All in one pile, so we can sort it out and start the process is where we like to begin.
Mm. So Tim, how does probate actually unfold in maybe smaller Indiana counties like Pulaski? Is it straightforward, or can it get complicated based on the size of the county?
We hope it doesn't get complicated. It's generally speaking, the estates and assets uh, in a small community, or we'll call it a more rural community, I guess
Right.
would be a better terminology.
Right.
We are in one of the least populated counties in the state of Indiana, but we're real rural and agriculture related. So we have estates and people who, range if you want to put dollar signs on it, from, someone who maybe never worked in their life and may have been a stay-at-home mom, and they've inherited from their deceased husband, and it might not be monetarily a huge matter, but it's a huge matter to handle those assets and to take care of it appropriately, all the way up to multi-million dollar farming operations.
Hmm.
So we have that wide range of estates and values, and they can be complicated, or I think just as complicated as anywhere else in the world or the state, if they don't have the right kind of planning in place. I think some of the biggest issues I see are people who have not done any planning at all. And it doesn't
Right.
take, let me put it this way, it doesn't take much money, because nobody likes to pay a lawyer to do anything, Evan. I can tell you that. Nobody likes to pay us, but boy, when
I
they need
know.
us, we get to clean up the messes. One of the messes I see quite frequently is someone who didn't do any planning at all, who didn't do any planning at all, which could be as minimal as doing the right kind of deed to name people, or putting instructions in a will. We recently had a situation where a single older guy died, and he wasn't married, didn't have any kids,
Mm.
didn't have a will. His home was worth $60,000. He had a truck worth about $5,000, and he had about $3,000 in the bank. And if you're doing the math with me and you paid attention earlier, that doesn't add up to over $100,000.
There's not.
That's under $100,000. So normally we would be able to handle his estate without going to court, without going through the probate process and doing things to the. I'm pointing this way because this way is where our courthouse is. For those of you who don't know Winnemac, so we go through the court system to do probate, but his wasn't over that 100,000 limit. But here's what happened: his dad was kind of a rascal, I guess, is a way of putting it. His dad was married twice. His first marriage, he had 9 kids, and his second marriage, he had 8 kids. So this guy who died had 17, do the math, 17, 16 brothers and sisters. So 6 of those brothers and sisters had already died. Well, this guy doesn't have a will. So in Indiana, you have to look up the law on where things are going to be distributed and to whom that property is going to go to. So under Indiana law, we look to different levels and parents and aunts and uncles and everything else. So it would go to his brothers and sisters, or if a brother or sister died, it would go to those children. So
Wow.
we went to about, I think, 27 or 33. I can't remember. I've had a couple of these in the last. So we went to, I think it was 27 people or 37 maybe, that with this bunch, that if I would have just done things non-probate and not going through the process, we would have been deeding the property, a $60,000 property, to I think 37 people that would be on
Wow.
the deed, and some of them we couldn't find. So yeah, wow. I mean, you should be sitting in this seat and see some of the wow messes that come through. And so what we did, and but like I said earlier, there's not much that we can't fix.
Hmm.
So there's a sister that came in, God love her. She took on this mess, and she came in with her husband, and And while we were doing all this, she lost her husband. He died. So we were
Wow.
dealing with that with her. But she took all this on, and I advised her, let's go through probate. Let's probate this anyway, because in probate, you will put you in charge. We can petition the court. You can sell the house, sell the truck, turn everything to cash. And now instead of property that might be deeded out with 37 names on it, we have a pile of cash, and we can cut checks and send it to the people that we have found. The people we don't find, there's ways of taking care of their money in the Indiana law and the processes that we have. So that's the kind of things that can happen. What this guy should have done, by golly, if he'd have talked to me, we'd have had a will in place, or maybe we have a deed that says transfer on death to my sister, and everything would have been taken care of, and easy peasy lemon squeezy kind of thing. So
It's
yeah,
incredible stuff.
yeah. So a little planning, and we have, I could bore you with lots of stories like that. We have many, many situations like that that have come up, and they're just painful to tell the families what we have to go through just to resolve what could be and should be simple asset transfers upon someone's death.
Mm. But based on all the things you said, in different scenarios, who could be responsible for managing this estate? If it was a different one, and how does that person kind of get appointed by a court if they're not going through all these things we just mentioned?
We were, well, like in that case, we were lucky that we even had a sister that stepped up to the
Yeah.
plate, because most of his brothers and sisters were estranged. You wouldn't believe it. Out of 17 brothers and sisters, you might have 2 or 3 that you hung with all your life, but that wasn't the case with this gentleman. He just was lucky he had a sister who contacted us and came in, and she was willing to take on that responsibility. He didn't have a will. If sometimes when those things happen, if we can't find a friend or a family member to step up to the plate, we have to petition the court, and we might have to have we call it a personal representative, or maybe you've heard the term executor or
Yep.
executrix. They're one and the same, two different names, same job. In Indiana, we try to use now more of the personal representative designation, but the court would appoint maybe another attorney for me that would handle being the personal representative. I've been asked by other attorneys to serve as a personal representative in estates that they're handling when these kind of things happen, or if they need to replace someone. If you have a will in place when you die, you have taken care of that. There's someone you name. If they
Mhm.
aren't available, if they've died, if they've become disabled, then you have a backup that has a successor personal representative. And we petition the court when we open up an estate. We file your will with the court. It names names, and those people will step up then, and they're appointed by the court, and we get all the legal documentation to make it official and give them the authority to manage the estate then.
Mm. So Tim, what kind of assets normally have to go through probate? What types can transfer outside of probate?
That's a good question, and we could probably spend a couple of hours trying answering that completely. The A good answer is this: the Indiana law has evolved to the point where almost every asset we own can be transferred in some fashion without going through probate. Everything that we own can be set up to be transfer on death, payable on death, beneficiary designation, life insurance, death benefits that pay out as a beneficiary designation. And that all sounds easy, and that all sounds well and good, but that's not always the best solution for someone's estate plan. Why? Because what if I die and I leave a $30,000 savings account to my daughter? Well, wait a minute. What if she died before I did? Who's it going to go to then?
Mm,
My 10-year-old granddaughter? Is that a smart idea? What if I die and leave something to her, and then maybe they're in the middle of a divorce? Uh,
mhm.
there's things that sometimes people they have this idea that if they put an adult child, on their checking account, I'll put them on as co-owner. I always would carry 20 to 30,000 in my checking account. I'll put them on as co-owner so they can help me pay the bills, and when I die, they're going to know to take that money and pass it out to the 5 kids. Well, when I die, all that $30,000 in my checking account belongs to that child of mine. Let's say it's my daughter, and it's her money. She doesn't have to divide it up. And even if I told her to, she's not legally bound to do that. She's a co-owner. So oftentimes you want to tell people that leave it to someone in your will, make it payable on death if it's a smart thing to do, but don't add a person as a co-owner. Name them as a power of attorney person that maybe they'll have the authority to write a check for you, but they don't own the account with you. But there's so many things that can go wrong by taking the simple, easy way out and just making an account or a property transfer on death. Not that we don't use those tools, but it's one of those situations where we need to sit down and talk to the families, talk to the people, and examine what they want to do, what their beliefs are, how their families operate. And by learning all that information, is it better to have a will to take care of transferring this asset? Would it be good to do a transfer on death deed? How about setting up a trust or something, or maybe even setting up a trust in the will that gets created after your death? So it takes some conversations. And one of the things that I feel like I say it in my sleep sometimes is I always tell people, when they sit down with me the first time, this is not going to be a one and done conversation.
Mm-hmm.
If you have any age on you at all, and that means if you're 25 or older, then it took you a little while to get here. Don't expect to get all the answers in an hour and 15-minute conversation with me. It's not always a one and done situation. And we like to learn about you, learn about your families, and really find out what you want to do with your assets. So
Speaking of that, Tim, though, how long does the probate process usually take in Indiana? What tends to slow things down?
if we're good and we're lucky and we have a good probate estate that we can manage and administer, we like to be done in 6 to 8 months.
Okay.
Sometimes we get done sooner than that. Sometimes they take longer. If litigation crops up, if family members want to fight about things, if we have trouble transferring assets. I had a one estate a few years ago where a woman she had died, but she was in a class action lawsuit because they have that webbing and mesh that they can operate and put inside you to
Yep.
hold things up and everything. She was involved in a lawsuit and we had to wait, I think it was 3 years for that lawsuit to settle before her estate got the payment from that situation. We had another one recently that was a multi-million-dollar estate that we had the estate, and the deceased gentleman had been the trustee on his mother's trust. And when he died, things in the trust were in a state of disarray, I guess is a nice way of putting it. So we had to wait almost 5 years with litigation and things that happened in that trust before what came out of that trust into his estate could be managed and taken care of. And that was, we don't like those things, but some things are out of our control. When we can manage it and do it well, and we have a really well set up estate plan, it's going to go smoothly. And we usually like to get them done in less than 6 or 8 months is our average we like to shoot for. So
Mm. What do you tell families who feel like probate is going to be overwhelming? How do you kind of help them see it's manageable and things can get done without the less stress as possible?
Evan, what I mentioned before, meeting with the families and taking time to educate people, taking time to give them the information and the knowledge they need to understand things.
Right.
I think that any of the things I've already talked about, some of them and people may have heard about and maybe not. Some of them maybe over your head, but each individual piece is not complicated. It's not difficult. But if we start stacking those, and well, okay, now we're talking about wills and transfer on death and the trust and powers of attorney, and now it gets more overwhelming and when I stack those and don't keep them broken down and talk about them in their each individual terms, they're not individually difficult, but together when you stack them, it gets to be a little overwhelming. So I like to educate people. Much like the processes I just described to you about probate. I want to make sure that they understand the processes. I want to make sure they understand that there may be periods of time when we may not communicate because we're just waiting. Probate processes have periods of time where we might have to wait 3 months and there's nothing going on. But the statutes say you got to wait 3 months until this date to do and take your next step in the probate process. So, Non-probate assets, on the other hand, can be transferred almost immediately. And I mentioned some of those non-probate process transfers would be the transfer on death, payable on death, those situations.
Hmm.
But in the probate world, and to answer your question directly again, education, spending the time, being patient with people. They're normally under a lot of stress and grief from just having lost a family member. They're not always thinking straight.
Hmm.
In our business and in the banking business and in financial business, it's a general rule of thumb that you should not be making any major financial choices and decisions for at least 6 to 12 months after you've lost a spouse or a close loved one. And we like to take very careful care about that when somebody comes in immediately after they lose someone, that there's choices that are going to have to be made, and we want to make sure that slow people down, and that they understand even through their grief, and maybe some not so nice family members that come a knocking. And that happens more often than you would think.
Hmm.
They come a knocking, and I try to always be a nice guy and handle things, but one of my jobs is also, okay, look, if those people are still going to be calling you up, texting you, emailing you, saying horrible things, giving you a nasty time, I hand them 2 or 3 of my cards, and I just say, pull out your lawyer card. I get paid by you to take care of all the nasty stuff. You don't have to. You send people to me, you tell them, I'm not going to talk to you anymore. You're going to have to go see Murray. And that's part of what I need to do for people so that they have a smoother and not such a bumpy ride. I'm here to take care of that tough stuff that people might give to relatives and friends after someone dies. So that's just part of the job. So
Hmm. Tim Murray, sir, thank you for your time.
thank you, Evan.
All right. That's it for today's episode of Protect What Matters, Estate and Elder Law with Mr. Tim Murray, a Winamac lawyer in Indiana. If you'd like to learn more about probate or estate planning in Indiana, visit tmurraylaw.com or call 574-946-7819. Thanks for listening. And don't forget to subscribe, share, and leave a review with somebody that might find it helpful as well. Thank you so much. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.